Hi all, my name is Chanchana Philip. I have been a professor in CMR School of Legal Studies for the past 10 years. So I am happy that all of you have registered for this online course, and as a teacher I will be giving lectures on criminal law. I have divided them into different parts so that it is easy for you and you understand the concepts better. Now, I have basically divided the whole course into two to call it as the substantive law and the procedural law. The substantive law being to tell you what is a crime, what's the definition for a crime, what are the various offences in India that you call it to be a crime, and the other part is the procedural law. In the procedure, when there is a case which has come up, how do you go with it? When does the police starts its investigation? When is it that an FIR is being filed? How do you go with a private complaint? Once a case comes, how does the trial happen? So that's the procedural part. To know what the procedural is, or to know how the procedural laws go forward, it is necessary that we first of all come to understand what exactly is a crime. What's a crime? What's an offence? What are the punishments for these offences? So only after knowing them, then we go with the procedural part of it. So let's start. So when you go with what do you mean by a substantive law, it is needed to know a little bit of the Indian history. Okay, so we divide history into the pre-Vedic period, the Vedic and the post-Vedic. Most of you who are history students or who've been in the habit of reading will surely know what was the situation in India during this point of time. Now, as far as criminal law is concerned, I should be telling you that this is something which was never foreign to India. In all this era, or through civilizations, when this concept of criminal law developed, India had a well-developed system of criminal law. And the good example for that is the Manu Code or the Manu Smriti that we normally come across. So that is part of discussion quite a long time, that has been in discussion for quite a long time. Now, Manu Smriti or the Manu Code was a set of codified laws which spoke about everything including criminal law, and you would be surprised to know that even the law of evidence with regard to at what time, how many witnesses for a civil case, how many witnesses for a criminal case, everything in detail was discussed in the Manu Code. But then one of the problems that were later on felt was the Manu Code was very strict in the sense that punishments were not proportional to the offence that had happened. It was disproportionate, meaning to say that the punishments were much more. So if the offence was something which was trivial, the punishment was much higher compared to the offence that was committed, for which there was a slight change when you see further, when you look at the codes of Brihaspati and Yajnavalkya, you find at that point of time, whatever codification of law has happened at that point of time, it was a little more lenient, unlike the Manu Code. Now, this being so, that means we knew what criminal law was as Indians. Our civilization taught us what criminal law is, what amounts to be an offence, against whom is this offence considered to be so serious. That is because you are treating an offence to be against the society. So, we will come to it. We will come when we do with the civil and the criminal differences, we will do with it. Okay. So, that was known to us. So, later on, during the 6th century is when you have the Turkish invasion, and around the 7th century you have the advent of Islam in India. At this point of time, and later on after Islam has been accepted in India, and when the population has accepted, when we had people following the Islamic religion, we call it to be a period of synthesis. That's the Hindu, Muslim community getting together. Okay, so they lived in harmony. But then obviously there were cases which came up, and when there were cases which came up, at that point of time there was no specific law to deal with them in common or in uniformity. So what each head or the village head or the town or the district head or the province head brought up was generally, if the complainant was a Hindu, they would try to apply the Hindu law, and if it was a Muslim, they used to apply the Muslim law. So this was a general practice. I am not saying it was a cut and right rule, but then the general practice, what happened? So it is and when this continued is when in 1600s we have the East India Company coming in. So when they came, you know, they came for trade, they came for business, nothing else bothered them. They were not bothered about all this, okay. And once they started keeping their foot firm, they understood the importance of having a uniform system of law for a country. So it is in this situation that you have the Regulation Act of 1773 coming into being. Now, why I specified on the Regulation Act of 1773 is because this is the first regulation which gave consent or assent for bringing in a criminal court in India. So once this came, there were there were Mufassal courts, you know, there was a Qasi who was appointed, and you know, these things happened. But still, you know, there was, understand that even though these criminal courts, so-called criminal courts, the named criminal courts were brought in, still the law was not confirmed. We did not know which law. Still then, even at this point of time, we don't have a uniform law. Is it the Hindu law? Is it the Muslim law? Is it their personal laws which ruled us? Does India have a common law, or do we apply the English law? No, we didn't know what to do. So it's at this point that there was, it's not that we did not know what to do, there was a prescribed system which was already there, and we tried to follow them. We didn't, you know, we did not think it otherwise until the Regulation Act of 1793 came in, wherein the European judges were appointed or were allowed to be part of the criminal system. They were appointed as judges. So that's when they were appointed as judges, they were looking out for a law to apply, which they found it difficult. It was difficult for them. First of all, they would have been in a language problem, obviously. Then they did not know exactly what the Hindu customary laws were. They did not know what the Muslim customary laws were. They did not even know when both the parties came together, which law would I apply. Now, if one of those parties were an English person, they did not know again which law to apply. So, this confusion came up when the right thought brought in them that it's high time that they have a common penal law for the whole of the country. So that's when, you know, so even before this, there was a situation wherein once the English judges were appointed, they started to take the principles of the English criminal law principles which were applied in England, which were applied in their country, is what they tried to bring in. That, you know, you call them application of those doctrines are called as a doctrine of precedence. So that doctrine of precedent was unknown to India. We never knew about it. We have never applied it. For us, as and when the case comes, the customary law has been applied, we take care of it, and you know, if you are from a different religion, according to the system that was already put in place, we either follow your religion, the principles put forward by person A or person B, that's how we follow. So, to take those principles which are already applied in one case to another case or from one country to another was not known to us until 1793, once the European judges were appointed, and they had no other go but to apply the English criminal law principles in India. But again, each presidency town in India had a different law depending upon the population that they had. They had a different law. They did not know which again law to be applied, and even when the English criminal law principles were applied, it could not be applied uniformly in all the places. So that's when they say, or they understand, that there is a need to have a common uniform penal system, and the Charter Act of 1833 paved way for such a situation. The Charter Act of 1833 brought in or suggested a reform, and the reform was to have a uniform system. and the first law commission was appointed with Lord Macaulay being the head of it, and discussed on what could be the various penal offences that can be brought under the penal system in India, and how to go about what could be the theories of punishment and how to go with it, and all has been, that's when they had discussed. So, or to put it in other words, it is the first law commission headed by Lord Macaulay who discussed on the various provisions that have to be included in the penal system that is to be brought uniformly into India, what is the theory that they should be based upon, what are the various punishments that has to be recommended, etc., etc., was discussed through the first law commission report. And then the law commission report or the bill was deliberated twice in the House, and in 1856 and 1857 it was discussed, and finally the Indian Penal Code of 1860 comes into existence. The major change which happened, or which we should understand has happened since this time, or for whichever Vedic period that we are calling through, and this uniformity of law coming into existence, the stages from where man protected himself to where the state is protecting him today. If you have noticed, let's say for example, when when a case has come up, let's say a murder case has come up, if you would have noticed, you will never find, obviously parents or the kith and kin will be worried people, or will be bothered about what has happened, but then it's always the police which interferes. So even if you don't have a case about it, somebody else is bothered about it, and who is it? It's the police. They even have the power to take a suo motu case when they come to know that there is a murder which has occurred, then there is an offence that has happened. So why is it so? That's because they represent the state, and for that there are different definitions given to what you mean by crimes. But a crime is an act for which there is some punitive sanction, and moreover it is also a moral attack on the society which is affecting the moral conscience of the society. That's what you call a crime. Now to move on with our next subtopic of our main lecture, we will have to look at mens rea. Now I introduce a new terminology to you, that's mens rea. This is the term that's used in common law, but then when it comes into the Indian law, we call them as, or we term it as intention. The intention of a person is what you call as mens rea in common law. Now how important is mens rea in criminal law? What role does it play? Now, when you go through the Indian Penal Code, as far as we are concerned, all the offences that have been mentioned in the Indian Penal Code have been specified or defined with specific ingredients. That is, what is it that constitutes this offence? Let's take for murder, or let's take culpable homicide. So, what accounts to, or what amounts to culpable homicide? That's been specifically mentioned. What ingredients will constitute this particular offence has been specifically mentioned. So we don't have to refer to anything else. We don't have to go anywhere else, because the code, the Indian Penal Code itself is wholesome, which tells you not only what all are offences, but it also tells you what all are the ingredients to it. But then it never came all of a sudden. I just want to introduce to you as to how this concept of mens rea came into being, and what is the situation of this mens rea when it comes to statutory offences. So we'll first go into it, and then we'll come into the Indian Penal Code, because mens rea has already been established, or the concept of intention has already been defined and laid down in the Indian Penal Code, but then where it came from, what is its background. Now how mens rea has been part of criminal law is what we will look at. Now for that, we need to first understand this concept of mens rea was never there. If you have done a particular offence, whether you intended it or not, whether it was a mistake or not, whether it was an accident or not, we could never read into this. We could never read into a person's intention. It was always the person has done it, he shall be punished. So it was always strictly interpreted. Even now penal statutes are strictly interpreted, but then the ingredient of mens rea was never read into any kind of an offence until almost till the 13th century. Whether it be common law, whether it be any law that you are speaking about, particularly we give stress to common law because Indian law has been influenced by the common law. Like we have already mentioned in the beginning with regard to how it came and how the IPC was codified and all those things, because we have already discussed on that. We have now an idea as to how we got influenced and how Lord Macaulay comes in and the Law Commission comes up with the Indian Penal Code. So we have a situation before this as well. So thereby how we were influenced, we have already gone through. So now when you look at it, when you look at the common law system or the criminal law that existed in the common law system, as I've already said, mens rea never had a say. There was no intention of it. I mean, there was no ingredient as such called mens rea. But then it was only by the 13th century, the Roman law brought in this concept of mens rea. So when the Roman law brought in this concept, the English or the common law system was influenced by it. And even they thought of having this concept of mens rea in there. And if you are a law student who is listening to me, I would like to introduce to you the maxim actus reus non facit rem nisi mensit rea. Actus reus non facit rem nisi mensit rea. Meaning to say, an act becomes an offence only when your intention goes along with it. The act and the intention should go together for that particular act to be called as an offence. This has been the base of any criminal offence that we speak about, whether it be common law or whether it be Indian law. So that's now been easy. So there are two ingredients that they are speaking about. One, actus reus, and second, mens rea. That's your act and your mind. So both need to be guilty. My act as well as my mind get together for that particular act that I did to be called as an offence. Now this is quite clear. Even when we look at IPC, it's quite clear. The only difference being that, as I've already told you, that mens rea is not what we call it under the Indian Penal Code. We call it as intention. There are various ways, there are different terms that the IPC has which reflects intention. Say for example, fraudulent, dishonesty, motive. So all this are various ways in which mens rea is read into the law. So that being clear, what we will have to analyze is, what's the status of mens rea in a statutory offence? That is, statutory offence meaning to say certain offences which are serious enough in their nature, and apart from the general law, they are being specifically categorized. The best example is Prevention of Corruption Act. You are speaking about the corruption, the act sees to preventing corruption among public servants. Prevention of food adulteration. The Narcotic Drugs and Psychotropic Substances Act. So these are all specific statutes which are made with an intention of understanding that these offences are something which are antisocial, and there should be special measures which are being taken care of. So they are interpreted much more seriously or much more strictly than those offences that we speak about in the IPC. So what about mens rea and in these statutory offences? Now why we do that is, most of the statutes would have avoided the word called intention. That's why I said once we start with the IPC, you will understand the difference, because in IPC, every offence is being defined. The ingredients of the offence is being mentioned. What constitutes an offence is being laid down. So it's easy for us. We know, okay, these are what it is, either this or that or both. So that becomes easy for us to understand how it works out in the IPC. But then when you come to a statutory offence, probably the statute might not have mentioned about the word intention or would not have read mens rea in it. So the problem of that is, if you have not read mens rea, then even if I have not intended to do an act, let's say for example, let's say it's a theft act, for example. Okay. So, I never intended to pick your pen, but then I just picked your pen. The very fact that I picked your pen can hold me liable, because the statute doesn't say look at my intention. Statute is not saying read my mens rea. So, if the statute is not telling it, then by all probability you will only look at the act that I have done. The maxim that we already spoke about doesn't get fitted here, because the statute is not telling you to read the mens rea. So, thereby if you have done the act, you can be booked. So, this being the situation, now there has been a series of case laws which have come up particularly in India with regard to discussing how important is mens rea in statutory offences. And for us to understand that, I mean, if we go with it, you can discuss on hundreds of cases, whether it be the common law or the Indian law. Because of the paucity of time, I just pick out a few landmark decisions which I would want to share with you. That's interesting, and which will help you to understand the law better. Now, when you come to common law, one of the most important landmark cases, which I am sure if you all are law students would have come across it, would have heard it, would have studied it, but otherwise if you are a layman, it is for you to understand that there was a case called R versus Prince. Now, R stands for Rex Origina, there is a king or the queen, so it's gone on an appeal, so that's why you call it as R. R, that's a short form. R versus Prince. Now, according to a particular statute, it's Offences Against the Persons Act. According to the statute, if a person takes away a girl below the age of 18 from the custody of a lawful guardian, he will be held liable. This is what the section said. Now, what happened in this case is, this girl had her friend to whom she had admitted or had made a statement saying that she was 18 years. So, when I say that I am 18 years, when you listen to it, you believe it, you take it. So, the boy really thought, okay, she is 18 years. Now, both of them planned to escape, and the facts turns out to be that there is a case against him for having taken away the girl from the lawful custody of her guardian without the guardian's permission. So, he said, where is the law? The law says if she is 18 and above, you not need to get the permission. So, that's when he comes to know that the girl was 16 years. So, now to us, he never intended. Now, as far as I am concerned, what I would think is, if he had known that she was 16, he would not have taken this step. He would have taken the permission of the lawful guardian. So, then the question came up as to should mens rea be read into the statute. So, there, the courts, it was actually a 16 judge bench, and out of 16, except for one judge, all the others went in favor of the law, saying that in such serious offences wherein the whole intention of the statute is to give a social protection, is to see to it that the girls are safe. That's been the whole idea of we having this statute. And if you try to read mens rea into such a statute, the whole purpose, object and scope of the statute can get diluted, and we don't have to read mens rea. So that's how mens rea was not read in statutory offences till we came to the next case called R versus Tolson. Now, what happens in R versus Tolson was slightly different, or the decision which came out in R versus Tolson was slightly different. I'll tell you why. Now, in R versus Tolson, the statute was also similar, but on a different section. Now, according to the statute, if you marry a second time during the lifetime of your spouse, you will be booked for the offence of bigamy. That is, marrying a second time when the husband or wife, either of your spouse, is living. This was offence that was mentioned. Now, this particular lady marries in 1880 around, and she is deserted in a year. Her husband deserts her in a year. Now, after that, she goes around in search of the whereabouts of her husband, as to know where he is, what has happened to him, and So, and then she comes to know that, it took a time of 7 years, and then she comes to know that he was traveling in a particular ship and the ship cast away, and there were no more details. So she believed in good faith that her husband is passed away, is no more, and she gets ready for a second marriage. And this is something which she did not keep secret, even secretive even to her second husband. She even tells it to him, and everyone knows about this. Is not kept as a secret, and she's been trying to find out the person which she failed to, and she is under a good presumption, that the person has passed away, and hence gets ready for a second marriage. And this is taken way back. This is taken like 7 years. Now, in this time, when she gets married a second time, her first husband walks in, and the husband files a case against her for the offense of bigamy. Now the question is, it's a statutory offense. Should you read Mencia? Do you feel that she would have intended to have cheated her husband and married a second time? Do you feel that she in fact intended to do the offense of bigamy? Did she want to keep the first marriage a secret, cheat somebody and marry a second time? The facts very clearly tell you that no, this is not what she had. She never had this in mind. She never had an intention of cheating anybody. That was the reason why this was even shared with her second husband. And she knew about it. He knew about it. Everyone knew about it. So now how do you read Mencia? Do you read Mencia? Because the offense the section or the statute doesn't speak about the ingredient called Mencia. And if you're not reading Mencia there, meaning if you're not trying to say she never intended, she has to be booked. Because yes, during the lifetime of the husband, whether you intended or not, you committed the offense of bigamy. You married a second time. So there, in this case, unlike in R versus Prince, in this particular case, the court says, no, you need to look at her intention. She never intended. It was a mistake of fact. The fact in the sense, what she came to know was that her husband passed away and was not there anymore. So now she comes to know that her husband is there. That was a mistake of fact. And she waited. It's not that she jumped all of a sudden to get married. No, she was deserted way back in 1881. And she's getting married a second time in 1887. So that very fact, when she got married in 1880. And so that very fact itself shows that, she never intended to commit the offense. And thereby, Mencia was read into the statute to say that Mencia should be read, she never intended. But mind you, this case or the decision that was taken in this case was not later on taken up. It was not later taken on in the future cases. And that a good example for that is R versus Wheat. Now in R versus Wheat, but then later on it changes. So in R versus Wheat, what happens is a person who was illiterate, did not know to read and write, goes for a divorce and instructs his solicitor, instructs his lawyer that he needs a divorce. He just instructs him that he needs a divorce, but then ultimately, even without waiting or checking or knowing as to whether he's got a divorce or not, he's obtained a divorce or not, he marries a second time. Here the question is, did he intend to commit the offense of bigamy? That is, if you have legally separated, that's fine. If you are not legally separated and if you still, she remains to be your spouse or he remains to be your spouse, you're not supposed to marry a second time. So when this came up, the court said they differentiated. They tried to bring a distinction between R versus Tolson and R versus Wheat. In R versus Tolson, what they said is she was under a mistake of fact. What was a mistake of fact? That her husband was not existing anymore. And it took her 7 years to take her second decision of marrying a second time. But whereas in R versus Wheat, what he did is, he just gave instructions to his solicitor and didn't even bother to wait or check whether he's got a divorce or not, for wherein he approached and he gets back to a second marriage. So there the court said, it's not a mistake of fact. R versus Wheat is a mistake of law. That was a distinction that the case made, and they went for not reading Mencia in the statutory offense, and he gets punished. So, R versus Prince, wherein they said, we are sorry, there is no mens rea in statutory offences, we will not read it, it is strict liability. Though even in R versus Prince, he never intended, because he was told that the girl was 18 years and he believed bona fidely that, or in good faith, that she was 18 years. But then the court said, no, that's if you go for such kind of interpretations, the object and scope of the act is going to be destroyed, and we are not going to do that. But then when it came to R versus Tolson, there was a slight deviation. But then that deviation that the court did or took up in R versus Tolson was not later on reflected in R versus Wheat. But then again, you have one more landmark case which I would like to discuss here. That's when, it makes the full sense of what we are talking about, and the case is Shiraz. Shiraz versus Garretson. Okay. Now, what happens in Shiraz is this particular statute speaks about a licensee who holds a license with regard to when you are having a liquor shop and when you are a licensee, and if you serve liquor to a constable who is on duty is an offence. In this case was interesting to tell you that when the constable walks in, he didn't have the armlets or he had removed the armlets, which made the person believe that he was not on duty. He was off duty, and that's why he's come and he was served liquor. So now the question is did he intend to serve a constable with liquor when he was on duty? No. I thought he had kept his armlets out, and I thought he was off duty, and if he was on duty, he would have had it with him. So the very fact that it was not there made him have a bona fide belief that yes, he is off duty, and that's the reason why he served it, which he would not have otherwise. Here the court once again came back with R versus Tolson and said, yes, you need to read mens rea here. Mens rea in statutory offences is also important. And thereby, that has been the tendency of the courts to say that even in statutory offences, mens rea is an important ingredient. Now, how is it that India looks at it? As far as India is concerned, I told you, we have the IPC, we have 23 chapters in the IPC, and we have almost all offences which are laid down. But then this that we are speaking about are not just offences which you put up in the IPC as well. There's something which is much more serious. So there you will, have to have specific statutes for those specific offences, and the law dealing with those situations is also different, So here, when you look at India, I will have to bring to you two important case laws. One, as you all know, should be State of Maharashtra versus M.H. George and Natulal versus State of MP. Now, State of Maharashtra versus M.H. George was still another interesting case, because in this case, this particular person travels from Zurich to Manila, and according to the Foreign Regulation Act, until like 2 weeks before he was flying, the law was that you need not declare even when you are in transit in India, you need not declare the gold that you possess. That was the law, for which 2 weeks before his travel, the law changed. Farah came up with a new regulation saying that even when you are in transit, that is, he had a hop at Bombay and then he was supposed to go to Manila. So then when he hopped at Bombay, he never declared that this is the amount of gold that he had. The reason being, he never knew that the law changed. He never knew that Farah has brought in a change in the law saying that I need to declare it. They caught him there. They caught him at the Bombay airport. So when they caught him, the question is, it's a statutory offence, Foreign Exchange and Regulation Act. So according to the Act, why is this Act come into being? This Act is there with a specific purpose. The object and scope is something which is different other than any other offence. It's an economic offence. So there they have not read mens rea. They have not included the concept of mens rea in the particular statute. So now the question is, should you read the mens rea for him? The fact is that he didn't know that the law changed. But we should not forget that a mistake of law is not an excuse. Ignorance of law is not an excuse. If I did not know the law, it's my problem that I did not know the law. that's not a ground for you to claim an exemption. You can never claim an exemption saying that, I'm sorry, I never knew the law. No. If you did not know a fact, I didn't know the lady was married, I'm sorry, it's a mistake of fact. But I did not know that this was a law of the country, it's a mistake of law which cannot be compromised with, which cannot be excused. So thereby, when we look at, State of Maharashtra versus M.H. George, the court said we are sorry about it. We cannot read this, a socio-economic offence, and if you try to read mens rea, everyone, most of them will go scot-free, and the whole object of the statute is going to be destroyed. So we are not ready to read mens rea in this particular instance, and the person was arrested. But at the same time, when it came to Natulal versus state of MP, in Natulal's case, he had applied for a license, for a trade license, and believing in good faith that he would get his license, he had already stocked up and kept provisions, rice and etc. in his go down on the belief that yes, he is going to get his license. Now, the particular authorities had cancelled his license, and they never took a step, or they never initiated to let him know that yes, your license has been cancelled. And because he got no information, he bona fidely believed, yes, that I am going to get this, I am going to get my license, and he stocked up everything. Now, when this was, and he was submitting an account of all this as well, and he paid the licensing fee as well. Okay, he went to that particular step. So, when they accounted for it, they found that he is kept in storage more stock than that is needed, or than that is being permitted according to the license, and they arrest him. Now, the question is, did he intend to do that? Did he intend to keep the stock beyond what the law allowed him to do? He never intended, right? Because he bona fidely believed that, yeah, I'm going to get a license. I paid the licensing fee. And the authorities have never got back to me letting me know that, yes, your license has been lost, or we have cancelled your license. I have not got any notice about it. Moreover, I paid the fee, so what do I believe? I believe in good faith that, yes, this is mine. I obtained the license. So here the court said, yes, even though it's a statutory offence, and the intention has not been read, intention has to be read. So mens rea is read in statutory offences. So that's how. So though in M.H. George's case, the court did not read mens rea, was not ready to read the ingredient of mens rea for him. When it came to Natulal, there was a change. There was a change in the attitude of the court and the decision that was taken up. Now, why I've given you the common law system. How is mens rea read in the common law system, particularly in statutory offences? We are worried about statutory offences because don't forget that I've already told you that in the IPC we have already laid down the ingredients, so we know what the ingredients are. We need not worry about the ingredients when it comes to IPC. We just have to see whether those ingredients are there. That's a matter of proof. That's a matter of evidence. Whether I intended it or not, whether I knew it or not, is a matter of evidence. But as far as IPC is concerned, it's clear cut. It's clearly telling you what is needed there for that particular offence. But then when it comes to a statutory offence, that's not the case. Mens rea would not have been said, that would have been left out, or that would not have been mentioned. Then do you read it? So that's what we see that's why I divided it into two, the common law system and the Indian system. So these are the landmark. What I have discussed with you are just the landmark decisions to introduce a particular topic to you, and the decisions for the common law are R versus Prince, R versus Tolson, R versus Wheat, and then the Garretson's case. When it comes to India, we have two landmark decisions. We have other case laws also, but then these two landmark decisions which will help you to understand the status in India, which is M.H. George and Latulal's case. Now that we have looked into mens rea in statutory offences, let's get into the Indian Penal Code of 1860. Let's go in detail. Now we know the situation of intention in a statute. Now, I've already told you about the Indian Penal Code and how we read the mens rea in the Indian Penal Code, and also you have an idea about it. Now, to get back to our Indian Penal Code, that is the Indian Penal Code of 1860, the whole code contains 23 chapters. Now, starting from it, every minute detail of whatever is needed for the particular statute, meaning to say, every term that is used, every definition, everything has been included in the IPC itself. in the IPC itself. And what are the different offences have been divided chapter wise. The IPC also includes the kinds of punishments that have been included, that will be provided for each offence. Now, when we come to punishments, as I think if you would have gone through the lecture on administration of justice taken by Professor Srinidhi, you would have come across the various theories of punishment. But then just to give you a recap, it is deterrence, reformation, retribution and prohibition. But then we also have now something which is called the multi-approach theory, wherein we believe that it's just not one theory which can be underlying any particular statute. It's put together. It should be the best of all this which has to be reflected in the statute. So that's the new approach called the multi-approach theory. So that has been already dealt in. So you can refer to that particular lecture to understand the theories of punishment, and then to go with the different kinds of punishments. As far as the IPC is concerned, the punishments that are given are death, life imprisonment, then rigorous imprisonment, simple imprisonment, and forfeiture, penalty, fine. These are the basic punishments that are provided under the IPC. A slight reading, I think, from sections 53 to 75 will throw light on the theories of punishments and the different kinds of punishments that the IPC has got. And to let you know, as far as the IPC is concerned, we have relied upon the deterrent theory of punishment. That's the main theory that is based on in the IPC. All right. Now let's go with it. Now let's go with the various chapters under the IPC. Now when we go with the various chapters under the IPC, one of the most important chapters which I would like to bring to light is the general exceptions. Is a chapter on general exceptions, and it's chapter 4. Now we have been having a thorough lecture on what intention is. Okay, if you have had that particular intention or knowledge, then you will be booked for this particular offence, on this particular punishment will be granted to you. Now general exceptions is that particular chapter which tells about a situation wherein even if you have done that particular offence, you will be justified by law. The law says that's fine. You did it, but you did not intend it, or you would have intended it, but that was the option that was left to you. That's general exceptions. So under what circumstances do you get an opportunity? Tomorrow if there is a case against you and you stand before the court, you get an opportunity to tell the court, yes, I did this. But then my case falls within chapter 4 general exceptions. My case will fall within any of the sections from section 76 to 106. So I just wanted to let you people know what exactly are there. Even there, we cannot go in detail because that is again another fora class. So let's just have a bird's eye view on what these general exceptions are. Okay. Now we have mistake of fact and mistake of law. I think I told you the differences. You will understand the difference from the case that we discussed with R versus Tolson and R versus Wheat, wherein we said the courts distinguished, saying that R versus Tolson was a mistake of fact and the other one was a mistake of law. But then here, the mistake of fact and mistake of law I told you is not an excuse. But then mistake of fact is included to be an excuse. By mistake of fact, A, thinking it to be B. Or when a police officer comes to arrest you, I thought, or when I inquired, I came to know that you were Mr. A and I arrested you. But then that is a mistake of fact which the police officer can be forgiven for. So that's mistake of fact, mistake of law. Then there is provisions for accidents. If you read the IPC, it's very interesting. There are illustrations given in the IPC which will let us know it better. When you are cutting wood and the sachet of the axe flies off and hits you, I didn't intend it to hurt you, but I can claim a general exception. If you are a child below 7 years, and that concept is called doli incapace. Doli incapace. When you are a child below 7 years, the law presumes that you cannot form an intention. Even if you had an intention, the law says no, you did not have an intention at all. The law does not want to read intention in a child below 7 years. Then comes the category between 7 to 12 years. So there you will have to prove that the child intended. Otherwise, you have been exempted. Then you have provisions for insanity and intoxication. When you again speak about insanity, let me tell you why we had done with common law is all the sections in the IPC have their base from common law. Now, common law has specifically will tell you or the decisions in the common law system followed is what has been reiterated in the IPC, but in the form of a section. In the common law, with regard to insanity, the law is called the Magneton's case or the Magneton's rule. Now, that is the law that is laid down there, which is brought in insanity in the Indian Penal Code. Similarly, you have general exceptions with regard to intoxication. Even when you are being intoxicated and if you have done an act. But that should not be a reason for you, because if that is the case, tomorrow I get intoxicated, I come and stab somebody, I am going to say I was intoxicated. But the provisions, if you will go through, you will understand that the provisions are well formulated. Because in these provisions, they are very clearly, even when you take up intoxication, the provision says that you will have to prove that you did not know what you were doing, or you did not intend to have the knowledge of the act that you were doing. So there the burden is upon you to prove, because you are taking up an exemption. The general law is you stab the person, A stabbed B, A will be booked. That's the law. But if I try and claim, no sir, I was intoxicated, no sir, I was insane, I did not know the nature of the act that I was doing, then the burden is upon me to prove that. So what should I be proving? If you go through these sections, I mean if it is section 84 for insanity, section 85 and 86 for intoxication. So you can, when you go through it, the sections are very clearly formulated. Even for intoxication, the section says, you know, you were incapable of understanding what you were doing. You were incapable of understanding whether it was right or wrong, or whether it was contrary to law. Why? Because it was a voluntary intoxication. Somebody had intoxicated you without your voluntariness. If you volunteer, you go, you come, you are intoxicating yourself and come and do an offence, don't claim this. This is not for you. These are sections who are for people who have been intoxicated without their knowledge or against their will. Without your knowledge or against your will, if you are being intoxicated. So the burden is upon you to prove it. That I fall within this particular general exception. It's the same, you know, when you speak about insanity also. The insanity test is similar. The section 84 test is similar as to the Magneton's test that is laid down in the common law. I did not know the nature of what I was doing. At the time of doing it, I was insane. I did not know the nature of the act. I was incapable of forming a particular Mencia that was needed for the particular offence, for the reason that I was insane. My mental faculties were not working properly for me to know the nature of the offence that I was doing. I became incapable. The burden is upon you. You need to prove that. So that's with regard to insanity and intoxication. And then, you know, you have certain communications made in good faith. Let's say communications made in good faith. When you are a patient and you go to the doctor, a doctor is always supposed to act in good faith of the patient. So the doctor says, Mr. So-and-so, this is your disease. Let's say all of a sudden you get a shock. You're like, oh, doctor. And let's say you get an attack. You can't hold the doctor. It is because of the doctor. It's because the doctor gave me this, he just spoke it onto my face. Is why, you know, I had to face this. You can't tell it to the doctor. What did the doctor do? He made a communication in good faith for your betterment, for your well-being. So there the doctor gets an exemption. Then again, there are situations of consent. When you are a child and you need an operation, they will automatically get the permission of the guardian. Now let's say you are an adult. You are an adult, 36, somebody brought you to the hospital, you are unconscious. I don't know where to go for any kind of a consent for you. But at that point of time, if I am not doing a treatment on you, you might lose your life. Under such a circumstance, as a hospital or as a doctor, I would have done a treatment on you even without your permission. I would have caused an injury on you. I would have cut anywhere of your wound. I would have done a minor operation on you. Just to save your life. You can say, why did you touch me? Why did you cause an injury to me? Yes, I did it. Their consent is presumed. You can't book the person, he has been exempted. So this, when we go through, these are the various kinds of general exceptions that are being provided under the IPC, and out of which the most important is from sections 96 to 106, and that's self-defense, to protect yourself from an attack. Now, even before that, let me tell you, there is one more section which I wanted to tell you, which is also called, the doctrine of self-preservation, which the law is not in favor of. And I would like to introduce a good case to you, which is called R versus Dudley and Stevens. Now, in this, just to give you a summarized version of the whole case, you find a couple of friends in a particular boat who have been cast away. They are in the sea. They don't know. They are trying to reach the shore, and they have no other option. They have finished with their food. They've been hungry. They don't know when they're going to see the shore. And there, they have a boy with them. And because they know the only two options are either kill the boy, eat on him, or all of you die. Because of no food, out of hunger, we die. So this being the situation, they plan to kill the boy and eat on the flesh. Once they reach the shore, and because the boy was eaten, they are being arrested. So they said it's a doctrine of self-preservation. So the court is like, you cannot call it to be the doctrine of self-preservation at the cost of another person's life. Yeah, you take it to be you can take it up, but then you can preserve, no issues. You take care of yourself, you have the right to life, but then not at the cost of another person's life. Okay, so that's a case law which came up, and when they claimed the particular exemption, they had not been granted that particular exemption. But then, another illustration which I would like to give you to understand this concept better is, when I am sailing a boat and I have 10 people with me, and I reach a particular position where I take it to the right, I have a boat which I will hit with 50 people. I have a boat onto the right which I might hit 100 people. I would rather not hit both because I've got only 10 people. But then if my boat has got 200 people, to save all this 200, I will be exempted if I cause some injury to boat A with 50 people. So that's all these are general exceptions, because you've done it in good faith. It's not that you did not intend. That's why I said these are situations where it's not that you are not intended. Yes, you intended. You knew when I turned to the right, I knew I'm going to hit boat A. I knew that there's 50 people. There are chances of them drowning. But then why did I take it? I took it so that at the cost of 50, I can save at least these 200. There are another 200 in my boat which I need to save. So that's the kind of decision that I've taken there. That's why the law, though knowing that I intended. So Mencia is there, my intention is there, my knowledge is there. I know very well, yeah, this is not what is going to happen. But then, at the same time, I need to protect these 200. So there the court is the law is justifying me. Yeah, we know that there is a reason. So that's how you look at it. Okay, so that's why I said it's not that you don't intend. It's not that saying that you go scot-free, right? Good. No, that's not the attitude that the courts have taken. It's our responsibility to go one step ahead to explain it. The burden is upon us to explain that your case falls within the chapter of general exceptions. And then when you come, we have the last part of it, that's section 96 to 106, which speaks about self-defense. Where in situations when you feel that the person comes to attack you, but you can protect yourself from the particular attack by causing an injury to the person. But then you have circumstances. You just for the sake of it cannot exercise the right to private defense. Let's say for example, when the police comes to arrest you, there is a kind of calm that the law expects you to. Just because he comes to arrest you doesn't mean you exercise your self defense. That doesn't work out there. So when it is a public authority exercising their lawful authority, you can't exercise this. At the same time, when I come with a stick to attack you, you take a gun and shoot at me thrice. It's not an exemption which you can claim, because the law has also laid down. That's why I said the IPC is very clearly told you. Even when you exercise this general exception, the law has very clearly laid down under what circumstances and what is the rule that you will follow. The injury that you caused should not be more than the injury that could have been caused to you. There should be a proximity in the injury that is caused as well. I should be able to say this is how he came. If I had not done this, this would have happened to me. So that's the kind of answer that I should be given, and don't forget that the burden of proving it is always upon me. Whenever I am taking up the case of general exceptions, the burden is always upon me. So I have no other option. I will have to tell them that this is what it is. So under those circumstances, and if the court is convinced that yes, you can claim your general exception, it is being granted to you. And again, I am telling you, it is not that you take it as a matter of fact, oh yeah, even it doesn't come to you as a matter of fact. It is, the burden is upon you to prove beyond reasonable doubt. That's one. And second, here they are not saying that there is no intention being read. Yeah, we know very well that this is what going to happen. But then the circumstance was such that I had no other option. Or the law says, yeah, we know that you have done this, but then we justify it. You have your reasons to justify and convince the court for which that can be granted to you. Now that we have had an overview of the offences under the Indian Penal Code, let's move on to the procedural part of it. So as and when it is also important, I told you in the beginning of the class that we have two kinds of laws. One is a substantive law and the other is a procedural law. Substantive law, as we have already looked into, we know that what it is and the Indian Penal Code, the offences, the punishments for it, and we have a good idea about how that works. Now, IPC is only telling you what are the various kinds of offences, what are the ingredients for it, what is the punishment for it, but IPC is never telling you how to go about with it. So for that we need to refer back to the procedural code, and we have the Code of Criminal Procedure of 1973. Now this particular code has got all the details with regard to how a trial should be happening. Let's say from the beginning, how investigation shall happen, how shall a trial happen, what are the provisions for bail, etc. So this is also a codified law with all these provisions with regard to procedural matters. Mind you, as far as evidence is concerned and how we produce evidence and what kind of evidence shall be produced, we have the law of evidence, which we have not covered here. We take here the Criminal Procedure Code. Now, even before getting into the particular subject, we need to know three distinctions. One, we have offences divided into three: cognizable and non-cognizable offences, bailable and non-bailable offences, a warrant case and a summons case. Once again, cognizable and non-cognizable, bailable and non-bailable, summons and warrant. Now we have a schedule called first schedule in the CRPC, which has laid down all these offences which is in the IPC, and it specifically tells you which of these offences are cognizable, which of these offences are bailable. So only after understanding this, we proceed on to the next stage. Okay. So what is cognizable and non-cognizable? All these are but easy terms. A cognizable offence is that for which a police officer gets power to arrest you without a warrant, and non-cognizable offence is an offence for which you can arrest a person only with a warrant issued by the magistrate. When you come to bailable and non-bailable, quite clear. A bailable offence is that for which you get a bail according to Schedule 1, which has been mentioned, and otherwise you don't, you will not be getting a bail. There are circumstances, but otherwise generally it is something for which a bail may not be granted. Now the third is warrant case and summons case, and that's based on the number of years you get as punishment. For death, life imprisonment and anything more than 2 years punishment, we call the particular case to be a warrant case, and otherwise the case happens to be a summons case. So these are the three broad classification of cases that is underlying the Code of procedural, the code of criminal procedure. Now, understanding this, now we move on to investigation. Now, when we come to investigation, the sections, the major sections are sections 154 to 173. Now, if I would tell you FIR, that's a very common name that you and me might know. That's the layman's language as to what an FIR. Oh, he has filed an FIR. There is an FIR which is filed. So, these are common terms which we have been using and which we have heard. But then if you refer to the sections, the exact sections of the CRPC, we don't find a word called first information report or what you call as an FIR. Okay. So, from 154 onwards starts the procedure for investigation. Now, before that, let me tell you, there are functionaries under the code, and the functionaries are the police, public prosecutor, defense lawyer, the court, and then you have the prison authorities. As far as the prison authorities are concerned, we are not covering it under the CRPC. We have other statutes specifically for them. But as far as the courts are concerned, with regard to criminal cases, which are the number of courts, what is their order, what is their hierarchy, what kind of a punishment can each court grant, all this is mentioned under the CRPC. And then they also speak about the power of the police, not generally, power of the police with regard to investigation covered under the CRPC. So, what are the powers of the police? So, we don't get a general idea about it, but then we get an idea with regard to when an investigation is going on. As far as a criminal case is concerned, what would be the procedure or what are the powers of the police is what we come through. And the moment you speak about investigation, we don't get in our mind any other picture other than the picture of a police. So, thereby, when you start with investigation, but even before that, though I told you about section 154, when you check with section 41 onwards, the powers of the police start, because you have arrest, how to go with an arrest. When you come to section 100, you have a search warrant to go for a search, seizure, procedure, all that is be taken care of. But then because of the time limit that I have for this particular lecture, I thought three important things I would cover in this procedural lecture that we are concentrating on. So, that's why I thought I will start with investigation, which would help the viewers. Now, when we go with the investigation, section 154 clause 1 tells about how if any person gets an information, you let the police know about it. A second way of how the police will get an information or the police will start investigate a case is when the police suo motu feels. The police comes to know that there is something which is happening and something which he has to investigate into it, then he can do it. That's under section 156. And then under 156 clause 3, you also have the court giving orders to the police asking him to investigate. So, when you speak about investigation, there are three ways in which this investigation can start. One, from an information from a person. So, that's what we call as the first information report or the first information. When I am in my station, how is it that I got an information? When you came forward and you told me, sir, this is what has happened. I came to know about something which has happened. This is an offense which has happened. So, that's the first information. You are the first informant coming to the police and letting him know. So, that's why we call it as, or the layman calls it as the first information. And that comes under section 154 clause 1. That's where the information is spoken about. And if you check with 154, that is all telling you about the procedure with regard to, how to enter or how to take the details or how to record the particular information that you have got. Now, there I would like to bring to your notice a couple of things which, as a layman, it is important that we know. One, this particular information that you have given to the police is supposed to enter it in their police diary, and a copy should be given free of cost to the informant. Second, you also need to keep in mind that in case the police is not keen in recording this, you also have an option of writing this and posting it to the superintendent of the police. I guess it's clause 3 of 154. You can send it to him, thereby reading on it. If he feels that the matter has to be investigated, he can take actions. So we need to know that when you knock at the doors, and if the knock at the doors of a police station, and if you are not getting the right response, our code is well obtained other provisions as well, wherein we have other options. So this is also one option which I wanted to let you know, which is as part of investigation, and you get this particular copy free of cost. So there, that's one part. Then again, when you come to 156, if the police comes to know about it, or under 156 clause 3, if the court feels. So in any of these grounds, so it is not compulsory that it has to be an information from me, from you, or from anyone. It can be from any of these circumstances, any of these sources, the police gets an information. So once the information is taken, the FIR has been registered and investigation starts. Now when the investigation starts is what confuses, is what we need to look at. Now there are various provisions. I told you, officially it ends up at section 173, starting from 152 till 173. So we have various provisions inside that. Okay, so we have, now even in this we have situations wherein if it is a non-cognizable offence, then you cannot without the permission of the magistrate go about with the case and all those things. Then again, if you need a search and a seizure, we have provisions in it which speaks about, you need to get the permission of the magistrate if you want to issue if a search warrant has to be issued. Now how to go about with it, all this I have already told you even before the investigation happening. So all those provisions will be reflected here. Accordingly, you can get the permission of the authority and you can move forward with your investigation. Now when you move forward with your investigation, there is a particular phrase which is used. That's the police gets the power to ask questions or to investigate the matter, and when he is asking, he can interrogate people or he can question people. And who are these people? Not anyone, but people who are acquainted with the facts and circumstances of the case. So when you say acquainted with the facts and circumstances, don't have the thought that it is only the accused who is being questioned. No, it's never the accused who is. You can be anyone who knows about it. I know about it. I know, I saw that. I was part of it. I was his neighbor. I was his friend. I was his family member. Whoever you are, you could be acquainted with the facts and circumstances. So the police gets an opportunity to question all of you, and then statements are recorded. So those statements, now something that we need to know is, those statements which are recorded by the police are generally called 161 statements. Now these statements which are recorded, under 162 the section speaks about the evidentiary value of these statements. Now when you give these statements, this need not be signed by you. Now if you read it along with, this is 161 read along with 162 will tell you the status of the statement that you have recorded before a police officer. Now generally this has to be read a little bit with the law of evidence. Now when you read it with the law of evidence, you understand that generally a statement which is made to a police officer is not being accepted. But it is not that it is completely denied, but if you read it with 162 CRPC, it has got an evidentiary value during the course of trial for cross-examination. Or when you are doing a re-examination, when you would want to do, you can rely on this particular statement. So there the code is specifically telling you these statements that you have recorded has got this validity and only this validity. So that's when, so when you want to check the veracity of the witness, when you want to know how truthful the witness is, when you want to check with the credibility of the witness, you can use these statements to contradict him. That's been permitted. So the law is very clearly telling you, for what all will these statements. So that, now why we have these provisions is so that the code or the law is very careful in not allowing any authority to misuse their power. So there could be things which could be added, there could be things which can be, along with your signature, because if your signature is there and whatever has been added to it, you can be forced to sign it and it can have an evidentiary value. That's the reason why the law is very clearly telling you, you don't have to sign it. And also it is telling you, if at all you have, if the police has taken any kind of a recording, then what kind of an evidentiary value will these statements have? So then, So is it that the investigation doesn't reach anywhere? So how about you confessing? Is it of no value? For that, you need to come to section 164, which tells you about how valid can your confessional statement be. That is valid, or your confessional statement becomes valid when it is written. It could be a confessional statement or any statement. When we read to the section, you understand this, it's a confessional statement or any statement. Why I said any statement is because there's a difference. Confessional statement is when you speak out your guilt, and mostly that comes from the accused. And statement is because we already said a person acquainted with the facts and circumstances. So a statement could be a statement made by any person. But the whole issue is how valid is the statement? Tomorrow when you take it for trial, is this evidence, is this document valid? Is this statement valid? If you need to know that, then 164 is helping you out by telling you we have one way. Don't think whatever you told to the police is thrown off and the statement has got no validity, no point. No. When you come to 164, it says to give validity to that particular statement, it shall be recorded by a magistrate. So thereby, with the power given by the magistrate, you get that particular statement that is recorded gets an evidentiary value. That we understand when we read it with the Evidence Act. Because under the Evidence Act, you have provisions which tells you under section 25, when you read, you can understand a confession made before a police officer is not valid unless and until recorded in the immediate presence of the magistrate. So there you are speaking about the evidentiary value of a confessional statement. When you read it along with 164, you understand that particular statement which you have recorded before the magistrate has got an evidentiary value under the law of evidence. So that's the connectivity that we have. Okay. And then when you later go on, one more section which is important is section 167. Now generally what happens is, again, that's a common thing that we come across. You arrested me, you need to produce me before the magistrate within 24 hours. Yeah, that's the rights of an arrested person. That comes under from sections 41 onwards where arrest provisions are done. That's where we come across it. But otherwise, the police has got no authority to keep you beyond 24 hours because under section 167, you have provisions which says, police, if you are not able to comply with or complete your investigation within 24 hours, then what? So that's under section 167. So there you have a procedure wherein it has to be recorded. You will have to tell it. You will have to convince the magistrate that we couldn't finish the investigation within 24 hours. I'm just giving you a summarized version of it. Okay, you couldn't finish it, so convince it, and you are given much more time. And that's where you get the next common term that we come across: police custody. So where does this come from? How do you use the particular term called police custody? What do you understand from that? Within 24 hours, I could not comply with my investigation. I couldn't complete my investigation. I have approached the magistrate, convincing the magistrate that, magistrate, I'm not able to complete it in 24 hours. Can I get the accused with me for further investigation? So I need to convince him that it's a cognizable offense. I need to convince him cognizable. Don't forget that we have done cognizable is that for which you can be arrested without a warrant. But then I can't keep him for beyond 24 hours. So then I bring him to the magistrate to let him know that that's the right of an arrested person as well. So when I bring him to the magistrate, 24 hours is getting over. I need him more for investigation. I couldn't complete my investigation. And I'll also have to prove that it's a non-bailable offence. It's something which is serious. Or let's say it's a warrant case. It's something which is serious for which punishment can be death or life imprisonment, anything above 2 years. So there you get the permission of the magistrate. So that permission of the magistrate goes to a period of 15 days. You can check through section 167 which gives you a detail of it. Okay, 167 which tells you about 15 days is the period of police custody. And it need not be one shot 15 days. It can start, depends upon the discretion of the magistrate. If the magistrate says, okay, bring him after 3 days, bring him after 5 days, that depends. That depends upon the kind of order, and every time the police is supposed to bring him, produce him before the magistrate. Now, however it is, now after 15 days, let's say, it's the Indian system, okay, we might not be able to, and the case will be so famous that, you might not be able to complete your investigation within 15 days. That's when you come and tell the court, 15 days is not enough. This has got so many intricacies in it that I am not able to finish it in 15 days. So what happens then? Then there is a proviso to section 167 which tells you, alright, if that is the case, if something which is serious for death or life imprisonment, you can go to a maximum period of 90 days. So that's a stop which the law is putting even upon the court. Court, how much ever you let the accused go into a police custody, when it's a serious offence, the maximum period shall be 90, and in any other case 60. So we will stop it at either 90, that's the maximum, or 60. After that, when you read it, the section says, he shall is mandatory, he shall be sent on bail. So whichever is the offence that you have committed, the maximum period where the police keeps you is 90 days, as the case may be, depending upon the offence, or 60 as the case may be. This will be the maximum. I am not telling the minimum, and this is not a cut and dry rule. This is depending upon the discretion which the court may extend, and not beyond this. You get a bail after this. Now, even in this particular circumstance, if the court feels that yes, he needs to be in judicial custody, particularly, if confession has to be recorded the next day or within 2 days, the police, it is very particular, the law, whether it be in law of evidence or in CRPC, tells that, the confessions have to be free and voluntary. It is a duty of the court to make sure that he is speaking out, whatever he is speaking out before the court is free and voluntary. He is doing a voluntary confession. So that's a duty of the court to make sure about it. We have those provisions also, or the procedure under section 161 as well. So thereby, what happens is, the police will not, no, I'll stop, you'll cut it, no, it's okay, no, okay, so thereby, no, yeah, I'm winding up, 2 minutes I'll wind up, what to do, listen, 2 minutes I'll wind up, so, yeah, so thereby, now in case the magistrate is not very particular with regard to sending them back to the police custody, and if a confession has to be recorded, the magistrate will see to it that it is made voluntarily, and for that particular period, the magistrate can send you back to judicial custody. So that's the difference between police custody. In police custody, you are under the threat of the police, or you are part of the investigation where they are using you for investigation, for search, to speak, to take you to the particular locality, to the particular place of where the offence has happened. So for all this, you will be with the police as part of the investigation. But then when you are in judicial custody, that doesn't happen. The whole idea being that you will have a free mind, and you will think about whether you need to make such confession or not. And you will be surprised to know that when you come to the court gives you a warning as to if you are not compelled to make such a statement. If at all you want to make such a statement, we will use it against you. So you think about it properly. That's the kind of warning that the court gives. So that much of care or protection is being taken with regard to the statements that are being made. But once you have made it, this statement, unlike the 161, is being signed. That means it has got evidentiary value, and you call it to be a judicial confession, which is valid in tune with the law of evidence provisions that have been mentioned. So that's how the judicial confession has been recorded. And then by the time you come to 171 and 173, based on all the records that are maintained, 171 speaks about all the details that the police has to maintain with regard to the investigation that has happened on a day-to-day basis, a person to person, whom all the persons acquainted, not to forget the persons acquainted with the facts and circumstances on a day-to-day basis, person to person, who all have you questioned, what has been their response, everything has to be recorded properly and it has to be paged. And at 173, when we reach section 173, the investigation report is complete and submitted before the court. So this is a summarized version of the process of investigation that can happen or that happens in a criminal case. Now that we have gone through investigation, I would also like to bring to your notice that there is one more way in which an information with regard to an offence can be brought to the notice of the court, and that's by way of a complaint. You have section 200 which deals with how to go with a complaint, a private complaint, and the definition is given under section 2 clause D. You can just go through it, and in that there are two options. You go to the court directly. It's not through the FIR that we spoke about and not the procedure under 154. You go to the court directly, you submit your application to the magistrate, and the magistrate has got two options. Either before taking cognizance only means to say taking note of the offence. That means he will apply his mind and look into the matter. So he's got two options. Even before looking into the matter, he can ask the police. If you remember, I already told you, a police can start an investigation even on the orders passed by the magistrate under 156 clause 3. So here under 200, when the complaint is brought to the magistrate gets the opportunity under 156 clause 3 to exercise his power, and he can revert back to the police asking the police, I want you to investigate this matter, just look into it and get me back a report. Once that happens also, FIR is done and the whole procedure that we have already spoken from 153 to 174 happens, and under 173 the report is being submitted, and even there once the police is given the matter by the magistrate, then the procedure has to follow from 154 onwards. There is no turning back, there is no coming in between. That 154 to 173 until the report being submitted, procedure has to be followed. Otherwise, that's one option that the magistrate will have. Now, the second option that the magistrate has is, magistrate will not refer it to the police, but rather the magistrate will look into the matter. The magistrate will apply his judicial mind, will study the matter, and there we will not use the word called investigation. Magistrate would rather inquire into the matter. Inquire into the matter, that's the term that we use, and inquire into the matter and see to it as to are there facts for which the magistrate needs to move on with. Is it a case which there is some serious allegations? Is it a matter which is to be looked into? Even the magistrate has the power to take a call on that. And then once this is done, if the magistrate is taking cognizance of the offence, otherwise the magistrate is waiting for the 173 report that the police has to submit. Here, if the magistrate is not gone for that, then the other option is, so the other one will be a pre-cognizable stage, even before you are taking cognizance. And here it is, after you taking cognizance, you can proceed with the matter. The magistrate as such gets power to proceed with the matter. So this option, so apart from you going to the police under 154 when you come to know about an offence, you always have the option of coming with a complaint to the magistrate as well. But generally, if the magistrate feels the facts are of cognizable, amounts to of cognizable offence, the magistrate would want a detailed investigation report, and the magistrate will generally refer the matter to the police for further investigation. Otherwise, if it is anything else, the magistrate will look into the matter, take cognizance of the offence, and the charges are being framed. Now that we are completed with the procedural law, I would also like to give you a glance of what were the other offences that the IPC covers, because in the previous lecture whatever we have done, I have not spoken about the other offences, so I thought it would be necessary that I just give you a glance of what the other offences are under the IPC. Now, to your information, section 5, we have 511 sections, each of which is with different kinds of offences. As I told you, the ingredients for each of these offences as well as the punishments. Now, to tell you, they are divided under different heads. You have offences against state, offences affecting public tranquility. If you are saying offences against state, it's sedition is a good example for offences against state. Then waging war against the state. Then if it is offences against human body, you have hurt, grievous hurt, you have murder, you have culpable homicide and murder. So all these are various forms of offences against human body. Then you have offences against property, like the best example could be theft, extortion, robbery, dacoity. So all these are various offences under offences relating to property. Then you have provisions dealing with defamation. Not to forget offences relating to marriage, like let's say for example cruelty, bigamy. So all these are various offences relating to marriage. So all this has been included in the IPC. So whichever offences that we are speaking about, generally all the general offences are found in the IPC. But then if you remember, we had spoken about Mencia and statutory offences. So we have, apart from the IPC, we have other criminal statutes as well, wherein they call it to be a criminal offence because of the seriousness of the particular offence. So the best example could be Prevention of Food Adulteration, Narcotic Drugs and Psychotropic Substances Act, that is the NDPS. So all these are other various criminal law statutes which make those offences criminal. So with this we have come to the end of the lecture on criminal laws. The next lecture would be on commercial laws, and that will be taken care of by Professor Anish.